before we get started, what we have to do is a little bit of housekeeping because it's a unique circumstance, a unique situation with this type of webinar. It's important for those attending to understand that this is purely educational. There's no specific legal advice being given. Even if I answer your question, it's not specific legal advice to you. My answers will be as general in nature and not so specific to you, again, because it's not legal advice. There's no attorney-client relationship by you participating or me answering the question. If you are a client of the firm, which has happened in the past, please know that there's no attorney-client confidentiality while we're talking in such a public forum, okay? If you want something addressed confidentiality in a confidential fashion, then just reach out to me directly if you're a client. Also, and lastly, if you do need specific legal advice, we offer free consultations as far as your elder care issues, estate planning matters, probate concerns, asset protection. That's what we do. It's what we've done for over 20 years, and we're here to help, all right? So let's get into this. Before I move forward, and I should have said it a moment ago, usually works out pretty well, but I want to make sure you can see me and hear me and see my PowerPoint right now. If you can let me know in the chat box or the Q&A that all three things are a yes. You can hear me, see me, and the chat box. Good, thank you. Can always count on you, Norm. All right, so the questions, let's get rid of the stopping the share here. Now, what we're looking at is a couple of questions. Now, the first question, pretty straightforward. I have a relative in a SNF, called a SNF, or a skilled nursing facility, a nursing home, and they are on Medicaid. Do they still need to file their income taxes? And the answer is generally yes. So think about it. If your mom or dad or spouse was receiving Social Security, pension, retirement account distributions before the nursing home, before Medicaid, they're probably still receiving them. And the benefit of filing the income tax return, not only getting into the requirement of it, but the benefit of it is you might have a refund, all right? Or there might be money that's due. But the bottom line is if you do have income coming in, you should still be filing the income tax return if you were prior to the nursing home and prior to Medicaid itself, okay? Another question, my parents refuse to plan to protect their assets. I got to tell you, Gloria, we hear that one a lot. A lot of our clients are more, unfortunately, not taking advantage of planning in advance, all right? Planning in advance, it certainly is the goal. That is the objective of why we're here, to help families get their plan in advance, protect their assets in advance, so that we can minimize a crisis. But unfortunately, a lot of our clients are still coming in here in a crisis. It's just human nature. And when it's a crisis, it can be a financial crisis, or it could be a care crisis, or it could be both, all right? So in this question here, my parents refuse to plan, and refuse to protect their assets. And I hear this all the time, that they were never gonna need care. Dad unfortunately passed on, but mom is now 95 and was just admitted to a nursing home in New Jersey. She has about $400,000 in liquid assets. Is there anything that can be done at this point? You are her power of attorney. First off, being the power of attorney is good. You'd want to make sure, of course, that it has all the appropriate gifting, asset protection, income protection language in there. Now, New Jersey. I am not a New Jersey elder law attorney. I'm a New York elder law attorney. We're a New York elder law firm. So unfortunately, I'm not going to be able to answer your question as far as New York law goes. All right, as far as New Jersey law goes, forgive me, because the recommendation here for you is to find yourself a good, experienced elder law attorney in New Jersey. The laws between each state are slightly different, and I'm not going to give you New York's answer telling you it's going to work in New York or in New Jersey, because it probably won't. It'll be a little bit different, okay? With that said, though, talk to a New Jersey lawyer. But if it was New York, what we'd be looking at is, again, making sure the power of attorney had the appropriate language in it for gifting and asset protection and so forth. Then in New York, we're able to utilize a strategy called a promissory note and gift strategy. And the purpose of that strategy is for us, in this exact scenario where we have a single parent requiring nursing home Medicaid, but since it's so expensive, they're not going to be able to pay themselves. So we look at Medicaid, of course, to pay the bill. With a nursing home scenario, you're going to have that 5-year look-back period. The 5-year look-back period, that should be nationwide, so I think you're going to get hit with that in Jersey. And what that means is anytime there's any gifting or asset protection done within the 5 years prior to a nursing home Medicaid application, there will be a 5-year look-back. The purpose of the look-back is to, guess what? To look back at all the accounts and all the assets and see where they've gone. How has this person become eligible? And if there was any type of gifting or asset protection steps undertaken during that look-back period, then there will be a penalty. And the penalty is going to be a period of time in which Medicaid won't pay for the nursing home, all right? Now, New York, gratefully, has only had a 5-year look-back for nursing home care. We've never had a look-back period for home care until now. So community Medicaid in New York will eventually have a 30-month look-back period, which is half the nursing home of 60 months. And gratefully, it's not starting until January 1st of 22. It was supposed to start in 2020, it was supposed to start in 2021, but they postponed it due to the pandemic, understandably so. So we're meeting with a lot of clients right now with home care needs. We're protecting all we can, and we're getting that application in as soon as possible. If you want to know more about New York's home care Medicaid look-back implementation, go to our website, tullyelderlaw.com, Tully, elderlaw.com, and we have a video tab. You click on webinars, and we've been doing webinars for the last 15 months, and we've covered the Medicaid changes that are happening to New York home care pretty frequently. So just check that out for more information. Now, in the nursing home scenario, again, there's going to be that 5-year look-back period. The purpose of that promissory note and gifting strategy is that we can attempt to shelter approximately 50% of the remaining assets, okay? Now, what that would require is a gift and a loan. That's where the title comes from. Promissory note, that's the loan and the gift. Roughly half is gifted. Roughly half is loaned under this rather complicated promissory note scenario. The gift, as we know, right, when we're looking at a 5-year look back for a nursing home, is going to cause a penalty, and that's on purpose. All of the calculations here there's many variables that go into the calculations. How much is the income? What's the cost of the facility? How many assets do we have? How much in assets do we have? Are there any exempt transfers that can be taken advantage of? Exempt purchases that can be taken advantage of, such as purchasing pre-plans for funerals and final arrangements. So there's a lot of calculations that go into a promissory note implementation. Probably one of the more complicated things we do. A real point, however, Gloria, that you have to think about is, and again, New Jersey and a New Jersey attorney will be able to tell you more. If you're doing a promissory note strategy with roughly $400,000, you're going to have approximately anywhere from $180,000 to $220,000 gift. That's going to cause a significant penalty, which means the family's going to have to pay for the care for a period of time on their own. The tough decision and conversation you all have to have as a family is, and with the lawyer in Jersey as well, is whether or not the promissory note is going to be necessary, okay? I've had that conversation with clients here in New York, where if we have to pay privately because of a penalty, let's say for 2 years, let's look at the real scenario. Let's look at the mortality. Let's look at the horizon. Let's look at the soft issues, if you will. It's not just about the finances anymore. Now it's about mom. If we believe that mom is going to be able to stabilize and do okay in the nursing home for a couple of years, then this financial strategy makes sense. If we don't think that's the case, then the discussion with the New Jersey attorney is this asset protection strategy even worth pursuing? All right. Tough conversation, tough issue. I certainly know that. But it's something that you need to have with the New Jersey attorney. All right. If you bring mom to New York and establish residency here, which we could help you do, then we can help with all that. But other than that, you'll have to talk to an attorney in that state. Okay. Wish you luck with that, Gloria. So another question. I've been advised to get a will and trust package. What is the cost? Good question, Fran. So most lawyers charge flat fees when it comes to planning work, protection work, Medicaid work, or what we call life care planning. The benefit of a flat fee is it's capped. You're not going to be paying more. You're not going to be paying less. And that way, everybody enters the engagement with their eyes open as to what the costs are going to be. There's different services that we provide, all right? The three main ones that we provide are an estate plan, which is going to be for perhaps under 65 years of age on the healthier side. Then we offer what's called an elder care protection plan. That is generally for 65 and over or younger if there are health issues. That revolves around asset protection and the use of what's called an irrevocable trust. And I'll talk about it a little bit more in a moment. And then the third main service that we offer is the life care plan. That really encapsulates the estate planning and the elder care protection work, but also brings to bear the idea of Medicaid and getting care paid for. Now, our life care planning services are very different than any other firm out there because we have geriatric social workers on staff that literally become the coordinators of the care and advocates for your loved one during the care process, during the Medicaid application, and for the entire elder care continuum, if you will. So you're not asking about Medicaid, you're not asking about life care work, so let me go back to estate planning and our trust work. So estate planning can be rather on the simple or basic side, okay? And what I mean by that is every adult should have a basic, simple estate plan. Now, when we do it, it's state of the art, if you will. It's going to include all the appropriate language. But honestly, every adult from 18 and up, regardless of age, regardless of health, should have what we call a basic estate plan. That's going to be a last will and testament, a durable modified power of attorney, a healthcare proxy, and a living will. Again, I've done other webinars on those specific plans and those specific documents. In the basic plan, the power of attorney may be the most important. It's where you're appointing somebody to handle your legal and financial matters. And it has to be durable and it has to be modified. So what that means is the power of attorney should not be from LegalZoom. It should not be from Staples. It should not be necessarily from, you know, a criminal attorney that helped you with something or your family member years ago. It shouldn't be from your real estate attorney. It should be an attorney that specializes and focuses on elder care and planning work, because the modifications that have to be inserted into the form are crucial to be able to protect assets, protect income, and undergo the Medicaid application process. All right. So again, power of attorney, very, very important document. For a basic estate plan, like I just shared, and by the way, a will is a will is a will, but they're not all made the same. Our wills all include contingency trusts. If we have, God forbid, a grandchild inheriting because a child passed, we always want to shelter and protect that asset until they're older. So we build in trust language so that an 18-year-old doesn't inherit a couple $100,000. We also build in contingencies about disabilities and Medicaid for your beneficiaries. So our wills are going to be more thorough, comprehensive, lengthy documents. I've seen wills that are 2 pages long. I've seen wills that are 45 pages long. So it's important to know what's going into that, okay? So I cannot give you specific rates, as you can imagine. I'm sure you're expecting that answer. But what you're looking at is anywhere from about $2,000 to $3,000 for a basic estate plan. That would be whether single person, married couple, but we offer a free consultation. We could talk about that more. Then after the basic situation, while still in the world of estate planning, not protection, we offer a probate avoidance plan. So that incorporates the basic plan we just said, plus a revocable living trust. There are 2 types of trusts: the revocable trust or revocable living trust, and the irrevocable trust. The irrevocable trust is the one that's a part of the elder care protection plan. Irrevocable trust means asset protection, at least it should. The revocable trust is not asset protection because it's a revocable instrument. It's a tool that we use to avoid probate. Very, very significant concept. We want all of our clients to avoid the courts. We want all of our clients to avoid probate. The reason we want you to avoid probate is it takes a lot of time, it costs a lot of money or can cost a lot of money, and it is completely public. Everything that is in your probate petition to the surrogates court is out there for the public to see. And there are literally companies out there harvesting data, if you will, names and addresses of beneficiaries, assets that are being inherited. I know this to be a fact, that this is all public and the data is being used, because when we file a probate petition for a client that didn't avoid probate, we're getting postcards and letters from real estate investors wanting to buy the house. How do they know? How does anybody know there's a house for sale unless if they've been on at the clerk's office at the surrogates court in either Mineola, Riverhead, Queens, Jamaica, Queens? So avoiding probate, time, money, and privacy. Okay, so the revocable trust estate plan becomes the one we usually talk about. And again, you're looking at a price range anywhere from about $3,500 and up, depending on what else is needed within that plan. Often we're still, of course, including the trusts for minor children just in case, or the trusts for disabled beneficiaries, Medicaid beneficiaries just in case. But sometimes with that revocable trust plan, we get into tax planning and credit shelter planning. That's a marital estate tax strategy. I just covered that in a webinar about 2 or 3 weeks ago. So again, it's on our website if you want to learn more about it. The next plan, as I've shared, is what's called an elder care protection plan. The elder care protection plan will be the basic plan. So you'll have your will, your comprehensive modified power of attorney, healthcare proxy, living will, but then we also build in an irrevocable trust. And yes, again, there's a whole webinar on these irrevocable trusts on our website. The purpose of the irrevocable trust and the purpose of the elder care protection plan is to shelter and protect assets for a future long-term care need. Okay, meaning if somebody's going to need long-term care, which is generally your assistance with your activities of daily living, walking, bathing, toileting, dressing, grooming, eating, transferring, getting up and out of bed, or a chair. Those activities of daily living are literally what we do every single morning, right? We get out of bed, we walk to the bathroom, we use the bathroom, we groom, we get dressed, we eat. Those activities of daily living are long-term care. So if there is a need for long-term care, Medicaid is usually the answer. Not always, but usually. And Medicaid eligibility is about your assets, it's about your income, and it's about your care level. How much care do you need? And again, when we tackle a problem like this and help a family through it, we've got the attorneys and the paralegals working on the legal about protecting assets, working on the financial about getting the care paid for, but we also focus on the care to make sure your loved one's getting the best care possible, okay? So in planning in advance, I can't really do anything about the care issues yet because I don't know what they're going to be in the future, all right? With eligibility, the second part of eligibility is the applicant's income. I can usually protect it, all right? We can protect it here when we're applying for community Medicaid benefits. Of course, there's a lot of calculations to determine how much we can protect, but I still can't do anything about that now in advance. It's done at the time. However, when we talk about eligibility for Medicaid and the assets, that is something we can start to protect in advance. So this irrevocable trust comes in. Irrevocable trust can sound scary to some clients, but it is truly a pretty flexible tool. There's options, there's security, there's contingencies, there's ability to change trustees, to change beneficiaries, and it can shelter a whole host of assets. Real estate, where you could still sell it down the road if you have to, buy another property. So there's a lot of flexibility with it. So the elder care protection plan is going to be, again, the basic plan and the irrevocable trust. Now, when we do a trust plan, whether it's that probate avoidance plan with the revocable or the irrevocable trust with the elder care protection plan, our trust plans include what we call our client care program for 1 year. So we come on board, and a lot of other firms don't do this. So, and it's included in the service, all right? The flat fee you pay for the documents in the plan includes a whole year of maintenance. Questions, we'll give you the answers. Changes, there'll be no charge. Funding questions, what goes in the trust, what doesn't go in the trust, we'll have a funding meeting. An annual meeting, we'll sit down or Zoom with the clients and the children that are involved, perhaps the trustee, make sure the trust is being operated properly. That's all included. Questions about Medicare, we have an outside specialist that can help with that. We offer what's called a personal care assessment, which is really just a check the box assessment tool about the activities of daily living and the incidental activities of daily living. So all of that is built into our trust plans. And the purpose, again, is yes, protect your assets. Yes, to avoid a crisis down the road. But it's truly, when we do an elder care protection plan, it's truly about helping the family prepare for care down the road. Okay. Now, the elder care protection plans, again, irrevocable trusts are a more sophisticated tool, if you will, protecting real estate and so forth. The fees are a little bit higher than the basic plan. So generally, $5,500 and up will be the irrevocable trust plan, again, what we call an elder care protection plan, which includes the year of service. Okay. Whenever there's a trust plan, understand there's going to be a disbursement. If we have to put a house or change a deed into a trust, there's going to be a recording charge that has to go to the county clerk's office. So that's always on top of the legal fee. All right, hopefully that answers your question. What else do we got? Okay, so my wife, next question. My wife is in a nursing home. She's on Medicaid. There was a personal injury slip and fall case. How do we protect the settlement? Good question. We do see it happen. If your wife's already on Medicaid, like you say, you've already gone through the Medicaid process, made her eligible, dealt with the income issues, perhaps spousal refusal issues, and got an approval. That's good. But now, let's say $200,000 lands in your wife's lap next year. What do? Well, it's kind of what I referenced earlier, all right, when I was talking about that, the promissory note and gift strategy. That's the type of strategy that would have to be used if somebody on Medicaid in a nursing facility all of a sudden gets this lump sum of money, whether it's an inheritance, which could be avoided, or a personal injury settlement like this. So the rough answer is we use that strategy. We can shelter approximately half of the money that comes in. A lot of variables and a lot of calculations get done. The good news is you don't lose it all right? Your wife would come off of Medicaid. We would implement that promissory note strategy, and then we'd get her back on Medicaid when that's over, okay? So it is not horrible, it's not terrible. We don't spend all the money, we don't lose all the money, but there are some things you have to do. The timing is crucial, all right? So if it's something we can help with, please get us involved before you have a check in your hand, okay? So that we can time how it's all gonna be done, all right? So good luck with that, Luigi. Next question. I am now a Florida resident, but I own a house on Long Island. I was told I should do my trust and in Florida, my trust and will, my planning in Florida. I'm going to agree with that, Barbara. If you are a Florida resident, then that's where your domicile is. That's where your legal rights will be. So I would agree that you would undertake the planning down in Florida. If you were a New York resident, then I would say New York. But the fact that you're down in Florida, your intent is to remain in Florida, perhaps you're filing your taxes there, you're still able to transfer any New York real estate into a trust in Florida. Just like when we have a client in New York, we can put their Florida property into a New York trust. That's fine. I would suggest you consider having a power of attorney, perhaps for both states. They have different requirements. You can do that. Or a healthcare proxy for both. Those types of documents are very state specific. And it can't hurt to have a set of these documents for New York and a set for Florida, okay? Hope that helps. Next question, last question that we have here. How long is the process to become a guardian? Okay, so with that, John, I'll assume what we're talking about is a guardianship perhaps for an older loved one who's been declining in capacity. In an ideal world, we have a durable modified power of attorney in place. And if we have a power of attorney that's comprehensive enough in place, then if capacity is lost, we don't even have to talk about guardianship. Guardianship becomes a required conversation when we have a loss of capacity, sufficient to the extent that they can't make decisions or understand what a power of attorney is. And there's a loss of capacity and there is no power of attorney in place, or there is a power of attorney in place, but it's not sufficient. Several times a month, I'm sitting with clients and they're going, I have a power of attorney. I don't need to pay you to do a new one. We'll say, sure, let's see it. If it's good, we leave it alone. That's great. But a lot of the times when we're looking and reviewing existing powers of attorney, they're lacking the appropriate asset protection and income protection language. So we'd want to update the power of attorney. If there's still capacity, great, we're doing it as soon as possible. If there is no capacity, if there is a decline, and there's no ability to sign a new one or to sign a fresh one, then we start looking at guardianship. Guardianship is a procedure, again, you want to avoid it if you can. The way you avoid it is by having the proper comprehensive power of attorney and a good healthcare proxy in place. That's how you avoid guardianship. Now, if it's required, then you're looking at about an 8 to 10 month process. It can certainly go faster. It can certainly go longer. There will be court hearings. There will be interviews. The court will appoint what's called a court evaluator. That's typically another attorney that will do a little bit of research and investigation, some interviews as to what's going on, and they prepare a written report and submit it to the judge, basically their opinion as to whether a guardian is needed or not. There's two types of guardians out there. There's what's called a guardian of the person and a guardian of the property. The guardian of the person is where you are petitioning the court and saying, my mom is in risk or at risk of harming herself health-wise. She's not taking her medication. She's taking too much medication. She's taking medication 3 times a day. She's wandering at night on the street. She's out in traffic. There's hoarding issues. There's hygiene issues, bad decision-making. All of those would go into a petition for guardianship of the person. Guardianship of the property, however, is more about the financial accounts. And that is where your loved one is in jeopardy of harming themselves financially. They're being taken advantage of by the neighbor. There's somebody in the house living there for free who's helping themselves to the checking account. They've transferred the house out to somebody else. They're not paying their bills. Guardianship is all about examples and what's happening. It's not about a diagnosis, all right? So you can't go to guardianship court over in Central Islip or Mineola and say, I need a guardian because there's a diagnosis of Alzheimer's. It's not about that. It's about what can the person do and what can't the person do. What type of jeopardy or risks are there out there for them? And the judge doesn't like to get involved with these types of cases because what you're doing is the judge literally has to declare your loved one incapacitated and literally remove from them the right to make decisions, and then implant a guardian over healthcare decisions and about personal decisions or property decisions. It's not an easy undertaking, and it's not taken lightly. Okay, there are some risks with a guardianship. For example, if you brought a guardianship out of with good intent because it was needed for mom, but the judge didn't see it that way and the judge denies it all, there is a chance the judge can hit you as petitioner with all the legal fees of everybody involved, okay? So there's a risk out there for bringing a petition for guardianship. If it's brought in good faith and it's sincerely felt that it is needed, the judge probably or maybe won't do that. But the purpose of this fee allocation is to make sure people don't bring these types of petitions frivolously, okay? Again, all can be avoided with a good, solid, modified power of attorney and then the healthcare proxy that's drafted properly, okay? So those are all the questions. Took about 30 minutes, which is our normal allotted time. Let me see if we have any other questions out there. Okay, is Medicaid entitled to any of the proceeds on the sale of the home that a parent owned while on community Medicaid after they die? So I'm gonna read that one again. Is Medicaid entitled to any of the proceeds? So you have a parent on community Medicaid, they pass away, they own the house. Is Medicaid entitled to the proceeds? The answer in short is yes, technically they are entitled to it. Every state, and New York included, of course, has what's called estate recovery. And that's where if there are any accounts or assets left in the Medicaid recipient's name alone, that will then force it to go through probate or what's called an estate administration. And that's when Medicaid has the ability to recover against the estate, okay? So when we're helping a family or other attorneys that know what they're doing are helping a family, you try to do all you can so that the Medicaid recipient will not have an estate when they pass away. So you want to avoid probate, like I was talking about earlier. You avoid probate by having accounts jointly owned, or having beneficiaries, or having assets in a trust. The reality is, with real estate, it's a little confusing, because the law actually says you can have your home and get Medicaid benefits. All right. So if you're undertaking the application on your own, or doing with somebody that has not really done it before, the law says you can have the house and get Medicaid. That's fine. But the risk is just what you asked. When your loved one passes on, if that's in their name alone, the only way to get that title transferred to the beneficiaries is through probate or administration, and therefore Medicaid has a right to estate recovery. Okay. They don't get the whole house. They only get what they paid out. All right. Other questions here? Okay, so hold on. Are you saying that if you have a proper POA document, then there would be... So the question is, if there is a proper power of attorney, is there no need to file for guardianship? That's a tricky question, Doreen. So generally the answer is yes. If you have a solid, durable, modified power of attorney that includes all of the right language, then yes, the need for guardianship should be eliminated. However, if you have a power of attorney agent that refuses to act, or is doing the wrong thing and breaching their fiduciary duty, there still may be a need for a guardianship. So there's always a little asterisk or caveat, okay? Now, if you are the power of attorney agent, can you tell others that you're the guardian? The answer is no. There's a big difference between power of attorney agent and guardian, and you are not a guardian unless the court literally appoints you as guardian, okay? If you qualify for Medicaid nursing home care, do you have a choice of facilities? Good question. And the answer is yes, especially downstate New York where we live. The nature of the demographics, the amount of facilities. I've been doing this for 23 years. Every facility we've ever worked with has a Medicare/Medicaid contract, so they accept Medicare and they accept Medicaid. In other parts of the country, you may not have a choice. You might have to go to one within a certain radius, okay, of the resident's home. In addition, some other elder care or financial professionals may say, stay away from Medicaid because you don't get to pick the facility you go to. They're going to stick you in the ugly one. Generally not the truth, generally not a true statement in New York, okay? Some of the, quote, better facilities on Long Island and New York all take Medicaid. All right. You're welcome. All right, everybody. Great to see you again. Thank you for joining us. We will be here next Wednesday. Be on the lookout for the email or check our events tab on our website, tullyelderlaw.com. Again, we offer free consultations to talk about your planning, about the protection, about the Medicaid and life care work, and we hope to see you soon. Thank you. Bye-bye.